Hi everyone and welcome back to another video. Now, following the riots between the 30th of July and the 5th of August, there's been about 1,000 arrests and almost 600 people have been charged with a variety of offences including violent disorder and assault on an emergency worker. Now, the riots that happened were the result of misinformation being spread about the identity, background and nationality of the person who was arrested on suspicion of the murder of 3 children on the 29th of July. Now, the riots spread to all parts of the country by protesters, people causing violent disorder, call it what you will, against immigration. Now, in this video, I'm going to go through some of the claims that I've seen online following these arrests, and I'm going to try and answer some of the questions that people may not know about the criminal justice system that we have seen in play over the last few weeks. Now, I'm quite happy to do this video because one of the reasons that I started this channel was to educate people about some aspects of criminal law which I often see either deliberately misrepresented in the media or people simply confused by the way the criminal justice system operates. So the opportunity to do a video like this is very welcome. Welcome to my channel, Andy on Crime, where I talk about high profile criminal cases and other aspects of criminal law. With all that being said, let's get into the video. So the first question I'm going to answer, and hopefully it's going to appear at the bottom of this screen, is why is everyone who has been arrested with regards to these riots and has been charged, why have they been remanded into custody? So I've seen tweets from people asking why so many people are being remanded into custody, and one of the accusations is that this is somehow government or Keir Starmer interfering with and giving directions to judges to lock people up. Now, to answer this question, you need to look at the Bail Act of 1976. I'm just going to briefly talk through that as it will explain why so many people have been locked up. Now, in general, except for the most serious offences such as murder and some other specific circumstances, if you're arrested and charged, the presumption is that you are entitled to bail, which means that you will be released pending any trial or sentence, unless there are reasonable grounds for suspecting that the person, the defendant, might do something like commit further offences, fail to turn up at their next hearing, called failing to surrender to the custody of the court, or interfere with witnesses. Now, there are some other reasons, but I'm trying to keep it simple for the purposes of this video. Now, what appears to be happening here is that judges are refusing applications for bail on the basis that the defendant might commit further offences due to the widespread disorder that we've seen. The risk being that if these individuals are released, they will engage in more violent disorder and in doing so will commit further offences. Now, this is not a new law that has been created. What this is an example of judges looking at the current circumstances in respect of the violent disorder that we've seen and applying the law to that situation. This has nothing to do with pressure being put on judges. It's simply a reflection of the circumstances that we exist in at this present time. Now, the next question that I'm going to look at is why are people being arrested for a tweet? Now, I've seen this quite a lot online, and it's such a disingenuous remark to make, as it seems to discount entirely what the individual is alleged to have said. And if you read some of the tweets, and I have, including ones about burning hotels with migrants in them, then of course this could be seen as an incitement to commit acts of violence in the ways that we've seen. Now, the same principle applies if you are putting out tweets encouraging people to gather and commit acts of violent disorder. That could be seen as a conspiracy, and we've seen conspiracy charged, for example, in the Just Stop Oil cases, where individuals who were planning to commit acts of disorder were arrested, charged and subsequently sent to prison. Now, there seems to be a disconnect from certain people, whether deliberate or otherwise, that saying things online is a safe space to say and do what you like, and that's simply not the case. And I've also seen people saying that these arrests and charges are an attempt to curb free speech. Well, if we look at the European Convention on Human Rights, which the UK is signed up to, it outlines how free speech or freedom of expression is protected, and this is under Article 10, and you can quickly see that it's defined as not an absolute right, meaning that there can be limitations on freedom of expression, unlike, for example, the prohibition on torture, which is an absolute right and there can be no derogation from it. Freedom of expression is known as a qualified right. That means that it can be limited for certain reasons, and these reasons are things like the interests of national security, prevention of disorder and crime, or protection of health and morals. There are others as well if you're interested in reading about them. So if you are promoting violence, then this is clearly something that is not protected under Article 10, and you have no right to claim freedom of expression because it is a qualified right and not an absolute right. Now, the next question that I'm going to look at is perhaps the reason that you clicked on the thumbnail to this video. Individuals saying people are being forced to plead guilty and are only being allowed to use a duty lawyer who works for the government who is convincing them to plead guilty. I mean, this is just plainly false. The duty lawyer in a police station does not work for the police or the government. The duty lawyer provides free legal advice to individuals who are arrested and due to be interviewed. They work for a private company who is completely separate from the police or the government. And indeed, if you speak to some of these defence solicitor firms, you'll quite quickly see that some of them are no fans of the police. Now, the duty lawyer is optional for those who are arrested, and an individual can refuse legal advice, they can use the duty lawyer, or they are free to use their own lawyer that will usually be at their own expense. Now, with regards to people pleading guilty, lawyers are there to provide advice to their clients. They are given the evidence and the charge, and then they give the best advice that they can on the best way forward for the accused to plead. The accused can choose to follow that advice or ignore that advice. Now, one thing worth of note here, particularly with the charges of violent disorder, is that lawyers are required, and indeed they'll be asked by the judge when it comes to the initial hearing in court, they are required to advise their clients that they will be given a 1/3 reduction off of their sentence if they plead guilty at the earliest opportunity. So in the case of violent disorder, where the maximum sentence is 5 years, pleading guilty at the earliest opportunity for some individuals, especially where the case is particularly strong against them, can reduce the amount of time spent in custody by several months. The bottom line, however, is that lawyers are not magicians. If the evidence against the accused is strong, and there is a significant amount of video footage with regards to these riots showing the actions of the individuals who's been charged, then they're unlikely to have a viable defence. So their best option is to plead guilty at the earliest opportunity and get a reduction off of their sentence. That's not done as a way to put pressure on them, that's simply a reality of the evidence against them. The next thing I want to look at is why are people being dealt with so quickly through the courts? And we've seen this manifest in two ways. Firstly, people are being charged very swiftly, and secondly, people are being sentenced almost immediately. So what's going on? Well, the first thing to say is that the swift response from the police working with the Crown Prosecution Service is a product of the need for there to be a deterrence to avoid others being tempted to engage in this sort of disorder, where the police have been assaulted, buildings have been looted, and even a hotel has been set on fire. And when you're dealing with instances of mass civil disorder, the need for a swift response to quell further unrest is pretty apparent. Secondly, a lot of people are pleading guilty, which means that the courts can proceed to sentencing without the need for a trial. Now, with regards to sentencing, and I've seen people asking, well, why hasn't the accused in the Southport stabbings been sentenced yet? And they are possibly deliberately conflating two different things. In the cases of violent disorder which are before the courts, the individual has pleaded guilty and the starting point for the offence is not going to lead to a suspended sentence in a lot of the cases, i.e. the sentence is not likely to be less than 2 years. So judges will tend to sentence as soon as possible without asking for a pre-sentence report, which is where the probation service sit down with the defendant and go through their motivations behind the offending to understand the individual and then give the judge a recommendation for an appropriate sentence. Now, with regards to the Southport murder suspect, firstly, he hasn't offered a plea yet. And secondly, and perhaps most importantly, murder cases are significantly more complex than the cases of violent disorder before the courts. There'll be multiple witnesses, particularly in this case, pathology reports and other expert reports needing to be gathered before the case is ready to proceed to a trial. So in effect, by making that comparison between the Southport stabbing accused and the individuals before the courts for violent disorder, you are comparing apples with pears. Now, the final thing to say on sentencing is that there are 5 principles of sentencing. Most people are aware of the first one, which is punishment, but there are 5 principles. They are punishment, reduction in crime, including through deterrence, reform and rehabilitation, protection of the public, and the making of reparations. Now, depending on the specific case, one or more of these principles will play a bigger role when it comes to sentencing. Now, the fact that there has been widespread violent disorder will mean that reduction in crime, specifically deterrence, will be a more prominent principle when it comes to sentencing. That is why you are seeing people who could have been given suspended sentences if the sentence of custody is likely to be less than 2 years not being given, because these punishments or these sentences need to have an element of deterrence. And the final question that I'm going to deal with in this video is, why are the sentencing of the rioters being broadcast live on TV? Well, there's nothing unusual about this. Since 2022, sentencing remarks of judges in a multitude of cases, usually high-profile cases, have been broadcast live and shown on news channels as they happen. As I say, there's nothing unusual about this. You'll have seen the sentencing remarks of Valdo Calacane from the stabbings in Nottingham, or the case of Lucy Letby. Those sentencing remarks were broadcast live as well, as they are high-profile cases and of interest to the general public. That's all for this video. I'm sure some of the points that I've raised in this video will stir some interesting debate, so let me know what you think in the comments down below. If you did enjoy this video, then please do give it a like, and if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.